Good afternoon, Your Honor.
Good afternoon,
How's
Your Honor.
everyone?
Okay.
Very well, thank you. And yourself?
I'm okay. It's been better though.
Sorry to hear that. Seems like it's been quite the day for Your Honor.
Okay. Alrighty. Noreen, you ready for me?
Good afternoon, Your Honor.
Good afternoon. Today's date is Thursday, December 7th of 2023. I have before me index number 525824 of 2019. Counsel, is that correct?
Yes.
Thank you, Mr. Timoff. Who's here for the plaintiff?
Amy Marion on behalf of Abram Fensterman.
Thank you, Ms. Marion. And the defendant?
Itamar Chaimov on behalf of
Say your name again?
Itamar,
Sorry?
I-T-O-M as in Mary, O-R as in Robert. Chaimov, K-H-A-I-M-O-V as in Victor.
And I didn't hear what Your Honor said for the index number, so I'm just going to repeat it for the record if I could.
No, that's okay. He already said yes. I only need one party to acknowledge and be at the right case. Thank you.
Thank you, Judge.
Thank you.
All right. And this is defendant's motion to dismiss. Is that correct?
Yes, Your Honor.
Okay. What do you want me to know, Mr. Cottonmouth?
Good afternoon, Your Honor. My name is Itamar Chaimov. I am a defendant pro se in this slap action with the slum landlord retaliated against the tenant, well knowing that the defendant is disabled and low-income person.
Okay, you want the case to be dismissed because, finish that statement.
I'm going there, Your Honor. I'm trying to
No,
make
you're there. You're already there. Finish the statement. I'm seeking the case to be dismissed because.
We're here to conduct a summary judgment motion, 14 hearing filed by the defendant.
I want the case dismissed because.
Your Honor, because of the pursuant to CPLR 3211G, dismissing plaintiff complaint on the basis that this action involves public petition and participation as defined in New York Civil Rights Law 76A, subpart A, and does not have a substantial basis in the law, or it's not supported by a substantial argument for extension, modification, or reversal.
I'm not getting this. Okay, just slow down. Supported
by a substantial argument for an extension, modification, or reversal of existing law. As well, pursuant to New York Civil Rights Law, paragraph 70A, as an apple. Pursuant CPLR, paragraph 3211, part A, subpart 7, dismissing plaintiff complaint on the basis that the pleadings fail to state cause of action. Pursuant to CPLR paragraph 3212 H as in Henry, on the ground that there are no genuine material issue of the fact exists which would warrant a trial of this matter, or in alternative, pursuant to CPLR 3212. As well, pursuant to New York Civil Rights Law, paragraph 70A, scheduling a hearing to determine the amount of compensatory damage, punitive damages, owned by plaintiff to the defendant. Pursuant to 22 New NYCRR, paragraph 130-1.1, awarding fee and sanctions against the plaintiff. If not, in alternative, to stay this court entirely pursuant to CPLR 5519A, subpart 1, and pursuant to CPLR paragraph 5519C, and or CPLR 2201 confirming that all proceedings as stated in this matter, including order and judgment, entered in the office of the county clerk on February 1, 2023, NYSEF document number 380.
Say that again.
NYSEF document number 380. Until final resolution of the issue, defendant raised under appeal of this court decision, the order entered on January 5th, 2023, NYSEF document number 372, and amended decision order entered on January 25th, 2023.
Okay, stop.
NYSEF document.
Stop. Okay, so you're making an application to dismiss this proceeding under the anti-SLAPP protection, correct?
Correct, Your Honor.
Thank you. Ms. Marion, do you have anything that you'd like to say?
Judge, it's all in our papers to the extent that I would just highlight for the court, as opposed to repeating what's already in our papers, is that, first of all, plaintiff has already made this motion based upon the exact same facts and contentions, and there was already ruling by this court denying defendant's motion.
Objection, Your Honor.
And he did...
the objection is overruled, and hold on a second, Mr. Kimoff.
Right.
She did not interrupt you, and you will not interrupt her.
Your Honor, but she is misleading the court.
Mr. Kimoff, she did not interrupt you, and you will not interrupt her. Do you understand that?
Understood, Your Honor.
Thank you. Continue, Ms. Marion, and I will apologize.
The court already denied the defendant's motion pursuant to 3211A7 and 3211G, which was, as I stated, was based upon the same grounds as the present motion, and that dismissal was NYSEF document 108, which was citing Mabel Assets LLC 192 AD 3rd 998, a Second Department 2021 case that stated that defendant has failed to entirely demonstrate that the within action meets any of the criteria set forth in Civil Rights Law 76-A. Defendant's subsequent motion doesn't point to any change of law or any new evidence. Additionally, the plaintiff's cause of action have a substantial basis in the law. Plaintiff's action does not concern public petition and participation as defined by New York civil rights law, as set forth in our motion and is also set forth in the factual history of this case. This is a purely private dispute. Additionally, the defendant's actions that gave rise to plaintiff's claims do not concern lawful conduct. In fact, the complaint sets forth, as well as the testimony of Jacob Landau, which we heard from at a contempt hearing, set forth that there was a history of harassment, complaining, the defendant trying to extort money from Mr. Landau for an apartment, for a house in Bensonhurst.
Objection, speculation, Your Honor.
Okay, hold on one second. Mr. Kimoff, I'm going to say this is one last time. She did not interrupt you. You will not interrupt her.
Can I push for the court?
The very next interruption, this case is going to be over, and I'm not going to hear any other thing. You have an opportunity, when she finishes, that I'm going to come back to you.
Okay.
But if you interrupt one more time, it's going to be over. You understand that?
Yes.
Okay. Marion, once again, I apologize for the interruption. Continue.
That's okay, Your Honor. Thank you. And so the defendant's conduct, which was set forth as stated in the testimony of Jacob Landau, as well as in the complaint, as well as in exhibits, but specifically for this court, the testimony of Jacob Landau, which set forth that plaintiff was also trying to not only get an apartment for himself after he broke up with his girlfriend, who had the apartment in plaintiff's building, but that also he was additionally trying to get a job. He wanted.
Okay, counsel, I know those facts already.
Right. So those are the facts which establish that this is purely a private dispute, and that's why the New York civil rights law doesn't apply, because it has to be a matter of public interest, and a concern of a purely private dispute does not come within the realm of the civil rights law. Additionally, defendants' communications were made with knowledge of their falsity and with reckless disregard as to whether they were false. Your Honor had a full-blown hearing, in fact, and Your Honor found the defendant to be in contempt of court for making complaints to the DOB which were not substantiated, and therefore his claims cannot come within the civil rights law 76A2, because his communications were found by this court to be made with knowledge of their falsity. For all of those reasons, the defendant is not entitled to summary judgment, both on the plaintiff's complaint and based on the New York civil rights law. I just point the court's attention to the recent holding in Miller versus APPADURAI, the First Department 2023 case. It's instructive on New York's new anti-SLAPP legislation. In that case, university professors, there was a complaint about their provost, which touched on topics of public interest, but was not its focus. It was held not to be within the sphere of public interest. The letter from the professors containing of their complaint was deemed to be a purely private matter directed only to a limited private audience. Similarly here, even if defendant's housing dispute arguably, quote, touched on, close quote, matters of public concern, the focus of defendant's complaints concerned defendant's private waging of warfare against his landlord. And again, that site is 214 AB 3rd 455, the First Department 2023 case. Finally, the defendant acted with malice when he knowingly made false statements, and therefore he cannot come within the New York Civil Rights Law 76-A. Additionally, defendant's statements were neither true nor good faith opinion, which is also required by the civil rights law. Finally, I did say finally before, and I promise this is the finally, I apologize, is that I would just draw the court's attention to the defendant's statement of facts, or purported statement of undisputed facts. I believe there were 96 of them. I just wanted to get the docket number for the court, but the court could see a statement of his alleged statement of undisputed facts, which were all statements that are factually disputed. Plaintiffs responded to each one of those purported statements of material facts that are undisputed, but in fact they are clearly disputed. This is an easy lift legally for this court. Summary judgment motion must establish as a matter of law the defendant's entitlement to judgment, and his papers, the affirmation, the statement of material facts, and the memorandum of law are all fact-based, not a matter of law, but are all fact-based, and allegations of facts clearly establishing that there is an unequivocal dispute as to the material facts in this case, which precludes summary judgment for the defendant.
Mr. Kaiba.
Yes.
Do you have anything you'd like to say?
Yes. 1 second. Okay. As well, Your Honor, the complaint is premised upon allegation that defendant complained to the DOB numerous times throughout the course of a plaintiff's repairs without the proper permit, with the purpose of to harass plaintiffs. It's clear the plaintiff's goal in this litigation is to breach the defendant's First Amendment right.
I'm not getting this. I'm not getting this.
Mr. Kaimov, just talk slower.
Plaintiff's goal in this litigation is to breach the defendant's First Amendment rights. The First Amendment right of the United States Constitution guarantees the right of the people to petition to the government for a redress of grievance, for a redress of grievance, United States Constitution. First Amendment. The Pennington Doctrine immunize.
Hold on. She's not getting.
What doctrine?
Noerr, Noerr dash Pennington, Pennington Doctrine immunize party.
Before you continue, Mr. Kaimov,
yes.
Let me just say this to you. You cannot keep coming back to court on the same things that I've already addressed or another judge has already addressed.
It was not your
I've already made a ruling on this case regarding these same matters. You cannot do
I did not file a motion with you, Your Honor.
Sir, if another judge already made a decision on
Yeah, but it was not.
Mr. Kaimov, do not interrupt me.
We're having the conversation, aren't we, Your Honor?
Well, if I'm speaking and you're talking over me, we're not having a conversation. You just talking, and I'm just talking. If both of us talking at the same time, that's not a conversation. Okay? I'm saying to you, because I'm not going over this over and over and over again. I'm telling you, I am not dismissing this case. This case is moving forward. Okay? You made these same allegations under a different number, under a different article of the CPLR. You did it under the same article. You disguised it under something else. This case is not being dismissed. This is a valid case that's going on and on and on, which needs not go on and on if you would just follow the instructions of the court. You cannot keep coming back with foolishness, because that's what this is now. And I'm telling you, if you come back again, you're going to be held in contempt of court, and I'm going to fine you. You can't do this. You have to listen. You have to listen. Judge Bailey Schiffman told you to do something. Judge Bailey Schiffman told you not to do it. If she tells you to do it, you don't do it. If she tells you don't do it, you do it. You can't keep bringing cases, motions, just because. That's not how the court works. So this is denied, and we're moving forward. So, Ms. Marion, I'm just asking you to draft the order that based on
Your Honor, I object, Your Honor.
Argument, I am not going to sit here all day.
I'm objecting, Your Honor.
What I've already gone over. Mr. Kaimov, do not interrupt me. Do not interrupt me. Okay? So, again, you just want to keep interrupting. You cannot do that. Okay? This is not the Burger King where you have it your way. That's not what court is. The court is, the judge makes a decision. If you don't like the judge's decision, you go to the higher court. You don't keep coming back to the same court asking for the same remedies. That's insanity. Okay? And I'm stopping this insanity now. Okay?
May I say something, Court?
Marion, draft the order based on the papers and after oral arguments.
May I approach?
Mrs. out this case is.
I can't hear you, Judge.
It's okay. She knows what's the right. It's okay.
May I approach to the court, please, Your Honor?
Thank you. So, I thank you, Ms.
May I
Noreen. This case.
Miss Mary,
This meeting is over. You don't have to. That's it. Okay?
Let the record reflect that the judge is ignoring.
The record is closed.